Hello, everybody. And to those of you who have joined, welcome. My name is Deloshni Govender. I'm an HR business partner with a focus on system and reward at LexisNexis South Africa. And I'm very pleased to have everybody with us today. Today we have a very short session, so we're going to jump straight into it. It is a short webinar and it's the first in our new LexisNexis Agility Matters Express webinar series, which is designed to keep clients updated in a flash with the critical content that they need right now. So please look out for more topical and to-the-point content delivered in the Agility Matters format. The first session is brought to you by IR Network. We're pleased to also advise that we're launching our Severe Weather Events Resource Center, which includes the latest legislation, articles, and more. Which focuses around the legal and compliance aspects pertaining to severe weather incidents. You can find the link in the chat box, and it will also be shared with you after the session today. Today's session will be focusing on employee management in trying times, unpacking some of the complex management and leadership decisions at play during periods of crisis. These include some of the things that we have been experiencing in South Africa, the COVID-19 pandemic, the civil unrest in 2021, and more recently, the adverse weather events in KZN. We're very pleased to have Michelle Naidu here to outline the legal and compliance obligations currently facing our employers on a daily basis. Michelle is a trusted colleague. She's a partner at Mooney Ford Attorneys and a panelist at Acquittate Dispute Resolution Services. She has specialized in employment and labor law, employment equity, and compliance for the past 19 years. She represents clients at the CCMA, bargaining councils, and labor court, and is regularly appointed as an independent chairperson by corporate clients and referring firms nationally. We will have a very short Q&A after Michelle's presentation, so please do use the Q&A tab at the bottom of the screen to post any questions. Please reserve the chat box for general comments only. This webinar is being recorded and it will be made available to all attendees a few days after the session. Thank you very much, and Michelle, over to you.
Thank you very much, Delosh. Thank you for the introduction. To all our attendees, thank you for joining us for this Midday Express webinar on employee management in trying times. Thank you to the team at LexisNexis for inviting me to speak about this extremely relevant topic, which both employers and employees are grappling to cope with in these ever-changing times. In my first content slide, which you should see on your screen now, I've decided to address the issue of the legal obligation to reasonably accommodate. Now, I'm raising this at the outset because what I've been finding in the last few weeks, actually consistently over the last 3 years, with all the crises that we've faced, is a question of reasonable accommodation. And I thought it would be appropriate to start with explaining what this actually means within the context of our South African legal system. The root of this obligation for employers in South Africa to reasonably accommodate employees may be found under the provisions of the Employment Equity Act. Now, the commencement date of this act is 1999, making this act 23 years old this year. Many of you will be aware that the Employment Equity Act prohibits unfair discrimination, and I emphasize the word unfair, because, as many of you would know, the Act does permit fair discrimination, which is permissible on the grounds of affirmative action and the inherent requirements of a job. That's very important under the South African employment law regime, that we understand this concept of what is fair and what is unfair. In 2002, a code of good practice was published, which really dealt with the employment of persons with disabilities. And it is here where we find the first concept of reasonable accommodation being introduced as a legal obligation on employers. But remember now, this is in the context of the employment of persons with disabilities. In the next slide, you will see the definition and scope of reasonable accommodation under South African law. And this requires employers to make modifications and adjustments to working environments to essentially lift any barriers that people with disabilities may experience in the workplace. But what I found very interesting, and which I feel may have valuable application in these times that we face, these crisis management times, is that this same code says employers must also reasonably accommodate employees when work or the work environment changes or impairment varies, which affects the employee's ability to perform the essential functions of a job. Now, the reason why I think this is quite relevant in the current times is because many of us woke up a few weeks ago during the flooding that happened in KZN, and literally were unable to move out of our homes. And when we managed to get to work in many work environments, there was not much left of the work environment. So I'm simply trying to show you how bits of information contained in existing legislation and codes can actually be applied in these current times. And this is the source documentation or information. In the next slide, what I'm highlighting is the limitations. Now, the obligation to provide reasonable accommodation to employees in the workplace under various different circumstances. It's not just limited to persons with a disability. Is not something which is unlimited. One needs to understand that. Most labor laws try to be balanced. That is, affording certain rights to employees, but the consideration of those burdens or those obligations is also taken into account. And the legislature has done that as well when it deals with the concept of reasonable accommodation. It provides that the limitation or the stop sign at which you do not need to push any further as an employer is if that particular measure is going to cause unjustifiable hardship on the employer. And that is significant or considerable difficulty or expense to the employer. So you can imagine, as an example, if you're running an operation which is a steel smelter or shipbuilding operation, then those working environments may find it unjustifiable hardship in order to adapt their working environments to accommodate certain crises or the employment of certain individuals, such as individuals that may suffer from disability. Now, the point of going through the provisions of the Employment Equity Act and the Code of Good Practice and this limitation clause is because I predict, and this is my view, basically based on my experience, I'm predicting that the principle of reasonable accommodation is going to be developed in our law to have greater application, such as situations where crisis management is required, just like the ongoing pandemic we are facing. What if there's a resurgence of riots across the country? The blackouts is something we live with every day. Our taps have gone dry. And now the unpredictable and extreme environmental conditions, which is impacting on our working environments. Quite honestly, I feel it's a miracle that we made it thus far. But we have, and we've got to continue to keep our heads clear and straight when we are applying these legal principles in relation to our workplaces and how we can make contingency plans that can work. In the next slide, what you see is how this concept of reasonable accommodation has been broadened already by the various COVID rules and regulations which have been published over the past few years. Incidentally, LexisNexis has a very useful portal of all those rules and regulations that have been published over the past 2.5 years, and it's in chronological order to follow. From those rules, what you would note is that the Minister of Labour has inserted reasonable accommodation in the regulations and directives that employers need to apply during the time of the pandemic. In particular, reasonable accommodation of those employees who may have fallen ill, particularly during the pandemic. So again, you can see how the concept of reasonable accommodation, where it started from applying only to persons with disabilities, due to crisis times, we see this principle evolving into a broader field and having application under the COVID-19 pandemic. What you also note is a new code of good practice has been published. And that code of good practice, it's important to note that it's published under the Labor Relations Act, not the Disaster Management Act. This code is the one that replaces all previous health and safety codes that applied during the period that we were under lockdown. So this is a very important new code. And what you will see, which is also very interesting, is the concept and principle of reasonable accommodation is standing strong in this new code. The code says that an employer is obliged to reasonably accommodate employees who may refuse to be vaccinated. Essentially, what the code is saying, employers must try to find alternative position for those employees which would reduce their risk and exposure to COVID-19. It is clear, however, from my legal opinion, that the same limitation of unjustifiable hardship will apply to this obligation, which means if the employer is unable to reasonably accommodate that refusal, then the obligation is then lifted. In the next slide, we're going to touch on the principle which I've been asked very frequently over the last few years since we've been in crisis management mode, is the principle of no work, no pay. So the rather obvious question that I get on a daily basis is it legal for the employer not to pay employees during periods where the Disaster Management Act applies, during periods which is out of the employer's control? For example, the riots we experienced in KZN last year, and then more recently, for periods of absence during extreme weather conditions, such as the floods we experienced in KZN recently. The answer to that is trite and settled in law, that there is no obligation on the employer to remunerate employees during periods where services cannot be rendered due to circumstances beyond the employer's control. And this principle, whilst there was a lot of debates in legal circles about this, especially during COVID-19 lockdown periods when economic sectors were shut down, our labor court has come out and has confirmed this principle in the McSteel case, and I've put the relevant quote or extract from the judgment, which essentially says the reality in law is that the employees who rendered no service, albeit to no fault of their own or due to circumstances outside their employer's control. And the court refers to the COVID pandemic. The court says I'm not entitled to remuneration during that particular period. So this begs a very important question to my mind, and it's a question that I believe our organizers are running a poll at the moment on this question, and it's really relating to whether there should be more government intervention, legislation, and regulations around managing employment, particularly the employment relationship and the duties, the reciprocal duties that one has in contracts of employment during disaster situations. Given the amount or the frequency of disasters we've experienced recently, it comes as a surprise to me that not more guidance is actually given to employers to steer through these trying times. What we really left with is, as labor lawyers like me, having to go back into legislation and look at source material to try to predict the manner in which the CCMA and labor courts will be dealing with certain advice that we are giving to clients. That's what we went through before the issue of, before we got clearer guidance on mandatory vaccinations and how employers should apply those rules in the workplaces. That poll, you will be free to participate whilst I'm continuing with the presentation. In the next slide, we're looking at the consequences. I just highlighted some of the consequences of the disasters that we've faced. And you can see from that slide that these are the sort of common denominators that we've been seeing across all economic sectors. And the result is quite, the result is what is causing so much of concern in industry, because it's leading to the bottom line being affected for every company. I mean, if nobody's reporting to work, there's productivity, output, and delivery challenges. And at the end of the day, if we continue on this particular trajectory, it's going to lead to downsizing and job losses, which of course is something all of us want to prevent and avoid from happening. In the next slide, we just take you through some do's and don'ts. Please do consider each case that you're dealing with, or each incident in your working environment on its own merits. Please take time to understand whether that case relates to an incapacity situation, which is a no-fault situation, versus a misconduct situation, which is usually an intentional and willful kind of scenario. It's very important to draw that line because different legal requirements apply to procedural and substantive fairness for dismissals or terminations based on incapacity versus misconduct. Completely different requirements. If you get that wrong, everything else you're doing is going to be tainted. We also are motivating and punting for workplaces to appoint a crisis management committee made up of representatives of management and employees, and to consult over measures that can mitigate the impacts of the distress and anxiety that our workforces are facing at these current times. The consultation, the communication elements is absolutely key and must never be underestimated. The one don't I have put on the slide is please be cautious on rushing off to discipline employees, for example, who've been absent without leave during periods where there was well-known crises that we've experienced. A one-size-fits-all approach does not apply in crisis and disaster management situations. The CCMA will certainly be very critical on an employer who's rushing to seize an opportunity to discipline an employee where there may be very real circumstances which would be compelling, that would mitigate an offense that may have been committed during these periods. Finally, on my last slide, we just put out some recommendations to the employer as a support sort of measures. Now, these measures that are put up, they don't cost you anything. They don't require you to ask your FD for an extra budget. It's really a human resources management issue. It's going to require not just the human resource departments and IR departments, but managers across the board in every organization to start getting involved, to lend a hand and to sort of take a collaborative effort to keep lines of communication open, to be consistent in applying workplace rules and measures for reasonable accommodation. Don't underestimate the principle of consistency. The left hand must know what the right hand is doing in relation to these measures. And finally, be alert. Be alert and observant in relation to behavior changes that your workforce may be experiencing, because this is coming from some sort of stress and anxiety. Deal with it before it leads to a poor work performance issue, or before it spirals out of control into misconduct situations. Thank you all for your attention. That concludes my formal presentation on this issue. I'm now going to hand over to the facilitator, to our facilitator from LexisNexis, Deloshini Govender, who's been intently watching the question and answers, and Deloshni will be putting those to me, and I'll try my best to answer them for you. Thank you. Over to you, Delosh.
Perfect. Thanks, Nishi. That was excellent. Very, very, very helpful insights there. So before we get into some of the questions, I just want to give everybody another minute or two to post questions if you have any. I'd like to quickly draw your attention to the poll on the screen. If you can take a few minutes to complete that for us, and we will go into the Q&A session thereafter. Okay, Mish, so while the Q&A, while the poll is happening, I have a question for you. So what should happen with pay around the days that employees cannot get to work in the aftermath of incidents, such as the civil unrest with the damages on the road or the severe weather conditions with the flooding? What should happen with pay around those days?
So, look, it's a tough one from a organizational point of view, because companies have tried to pay for most periods of absences. For example, during COVID, etc., many companies have kept remuneration going throughout those times. However, if you're asking me what's the statutory requirements, there is no requirement for the employer to pay for any period where the employee is unable to render a service, whether it's the employee's fault or not. That is the legal position. So the short answer to that question is there is no duty to remunerate. What employers have done, however, to mitigate against the employee going home with short pay for that month is to give the employee an option of utilizing annual leave, which they may have in credit. Some employees are more than happy to do so, whilst others we have experienced have not agreed to willingly set off annual leave for such periods, in which case it will then become unpaid leave.
All right, perfect. So I think we've reached the end of our session, so I'm going to stop here. Thank you to everybody who has attended. To Michelle, thank you for sharing your expertise with us. You can also now view some quick information on the screen about our LexisNexis products that can assist with employee management during trying times. And as mentioned earlier, the webinar recording will be made available within a few days to all participants who registered for it. And you're welcome to share it with anybody who you might think will benefit from it. So stay tuned for LexisNexis and our future updates and upcoming webinars. Stay safe and stay well. Thank you, everybody.